Hi, what's going on, everyone? I'm Bob with 1L and back, and I'd like to welcome you to the criminal law and criminal procedure part of the Beat the Bar course. As we know, the bar examiners combine these two areas of law, criminal law, right, murder, manslaughter, all the theft crimes, all that stuff, with the criminal procedure piece. So search and seizure, all of the rules related to double jeopardy, all that good stuff. And really all we're going to do in this area, as with our other areas of law, we're just going to talk about definitions, and elements. So we'll get into this, and the first crime that we want to talk about is homicide, right? So we have all of these homicide crimes, and we will just jump right into it. So homicide on MBE is great, and I say it is great because once we get a handle of, we're going to see there's 6 types of homicide crimes, and I have, I think, a pretty decent way of visualizing it and then some tricks to remember it. Once we get a handle on the way that homicide is defined, the different categories that we can put our fact patterns, the different scenarios that they throw at you. Once we can see how to organize those different fact patterns, we're going to see this is really not that hard. Now, it is going to be completely different, as I said in that little opening. It's going to be completely separate, completely different from how we learn this in law school, which I think for most of us is a good thing, because in law school, what I would imagine your professor, what was one of the first things, or what was the main thing that we talked about in terms of homicide? We talked about that phrase, malice aforethought. The good news is that this right here, what I'm saying, this is the only time we're going to talk about malice aforethought anywhere in any of my videos. And the reason for that is that they don't talk about malice aforethought on the MBE. You're not going to see that phrase. So from this point forward, I'll just say we don't need to worry about that idea of malice aforethought. We'll leave it there. It's confusing and it's not even tested that way. So forget malice aforethought. We're leaving it behind. When we think about homicide on the MBE, I want us to, and this is, my analogies, they hit different groups differently, right? Some people are more into certain ones than others. So this may be a little bit more for the gentlemen, although the ladies, sometimes they love these shows too, right? So Last Kingdom, Game of Thrones, for my gamer friends, right? Assassin's Creed, Valhalla. The idea is when we think about homicide, we think about like our Viking friends, and we say make the square. Now, of course, our friends in, Norman, or I guess pre-Norman England, when they're making the square, they're going to kill each other, and we want to visualize it the same way here. And the reason why we're turning it into a square is not just me being silly. It's because when we think about murder, there are 4 types of murder. And so we're going to draw our square out here in a second. But when we see with our 4 types of murder, if it's murder, the fact pattern that we're talking about, it's going to fit inside of our square here, right? So it's either going to be intent to kill murder, intent to inflict serious bodily harm murder, felony murder, or what we call depraved heart murder. Now, don't worry, we're going to go through all of those, but here's the idea. If it's murder, it's going to fit inside of our square, right? It's going to be one of the edges of our square. If it is manslaughter, we're going to see that we have these 2 other crimes, right? Voluntary and involuntary manslaughter. And involuntary manslaughter, as well as voluntary manslaughter, are going to be outside of the square. And there's 2 different ways we can draw it, right? We can either split this in half and we can say, okay, this is going to be our involuntary and voluntary manslaughter here, or we can draw 2 different rings outside the square. You'll see as I get into explaining this, and whichever visual works better for you, I think you'll find that it works. But before we go any further, let's make this distinction between what's inside of the square and what's outside of the square, right? We said the square here that we've got is our murder square, and everything that's outside of it is going to be manslaughter. Now, one of the biggest keys with success on MBE, we have to keep the definitions separate, right? It's really easy, especially when you think about that whole outline, right? And even just the crim piece of the outline, there's a lot of terms, a lot of definitions. The only way that we're going to have a shot at really keeping them separate is if we understand what makes these different, right? Where can we make this distinction? And for us with homicide, how we're differentiating murder from manslaughter, we're talking about intent. So in other words, when we have one of these murder crimes, we're going to talk about an element of intent. Usually, right? There's one little exception with depraved heart murder there, and we're going to get into that, and you'll see how this doesn't get confused with the manslaughter piece. Just bear with me. What we want to understand is that with murder, typically we're going to be talking about intent. With manslaughter, we are never going to be talking about intent. So with our two manslaughter crimes that we have outside of the square, right, voluntary and involuntary manslaughter, those two crimes we never, ever, 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 ever are going to pick an answer that is connecting a crime of manslaughter having to do with someone's intent, what the defendant's intent was or lack of intent. Intent has nothing to do with the crime of manslaughter. So we never want to see any connection between manslaughter and anything having to do with intent. Okay, so where are we so far? We've outlined, we've at least mentioned our 6 homicide crimes. 4 of them, right, our murder square is going to be made up of intent to kill murder, intent to inflict serious bodily harm murder, felony murder, and then depraved heart murder, or what we sometimes will see referred to as reckless indifference to an extreme disregard for human life, right? Reckless indifference to human life. The idea is this is depraved heart murder, and we're going to see this is the one that people get most confused with those manslaughter things. We're going to tackle this at the end of our discussion here, because I think you'll see once we've outlined everything else, depraved heart murder really kind of falls into this category of its own, and I think it'll be pretty easy to see. But let's start simple. Okay, intent to kill murder. Simplest, right? I have an intent to kill you. I buy the gun. I walk up to you and I shoot you, right? The idea is there's no ambiguity. And by the way, how will you know what someone's intent is? They will tell you. They have to tell you. You are never going to infer intent. And this, guys, this is a big difference from how we think about this conceptually in MBE world, MBE land, right? This is a huge difference between that side and in the real world, right? So for my district attorney friends, when we're thinking about, when y'all, I should say, are thinking about, prosecuting, right, and proving the elements of intent. And this is a little bit of a digression, but this will make sense here. So when you're thinking about proving the elements of intent in real life, you're thinking about all this other evidence that you can argue to a jury, right? Okay, this shows this person's intent. And it's all about, and you can only, what the person says might be evidence of their intent, right? But it's not dispositive, right? The person says, oh, my intent was, I didn't want to kill him, I only wanted to hurt him, right? The idea is in real life, and this is the last thing I'll say about real life in this section, in real life, you're going to say, okay, well, that statement that the guy made about his intent, that's evidence of the intent, but that's not where the story ends, right? You, ladies and gentlemen of the jury, you have all this other evidence, right? Blah, blah, blah. No. For MBE, the person's intent is what the facts tell you the person's intent is. We don't argue with the facts. We don't get into applying any type of lawyerly thinking around what someone's intent would be. It is just what they tell you in the facts. So they will say, the banker or the janitor or the plumber, whatever, they give you these names on the bar exam. The banker wanted to kill the maid. And so it's right there. There's not going to be any ambiguity so long as you read closely. So the simplest one, if we have murder, if I intend to kill you and then I kill you, that is murder. Intent to kill, murder. Simple, easy. We don't need to overcomplicate it. So long as we trust, and this is really what it is. It's trusting what you're reading in the facts. If they tell you I intended to kill the person and I killed the person, then I'm guilty of intent to kill, murder. All we're doing for crime, for MBE on the homicide piece, if I say I intended to kill the guy, it's intent to kill, murder. If I didn't intend to kill the guy, it's not intent to kill, murder. It might still be murder, a different kind of murder, but it's not going to be intent to kill, murder. And we're going to talk towards the end of this video about some of the different ways that it's tested. But right now, all we need to be aware of, intent to kill, murder, they have to give you in the facts that that person had the actual intent to kill the other person. Okay, so if that's intent to kill, murder, now we have intent to inflict serious bodily harm. Now this, again, kind of just going on what I was saying, people tend to get this confused. Occasionally they will test this, as they will say, what is the most serious form of murder that Bob can be convicted of, and choice A will say intent to kill, murder, and choice B will say this other thing that we're about to talk about, which is intent to inflict serious bodily harm, murder. So the idea with this is that if I take, the baseball bat or run you over with my car or whatever, and the facts say I don't want to kill the person, I don't want to kill you, I just want to injure you, right? You aggrieved me in some way, and so now I'm going to beat you up. Not really, right? But for the purposes of our bar prep explanation here, I'm going to beat you up. And so if I do that, if I take the baseball bat and I, hit you over the shoulder with it, and, my luck, your neck breaks, something happens and you die, well, am I going to be guilty of intent to kill, murder? Or am I going to be guilty of intent to inflict serious bodily harm, murder? What is the difference, right? Where do you go? Where do you go to know what my intent was? You go to the facts, and the facts on MBE are going to say either one of two things. They're going to say, Bob was super mad at you, you stole my girlfriend or whatever, and I'm coming to get my revenge. And the facts will either say Bob wanted to kill the person, or they will say Bob, wanting to injure the person, took the baseball bat and hit him over the shoulder with it, right? That's the difference. That is the difference between answer choice A and answer choice B in that question, right? Because if the facts tell you that I had the intent to kill this person, we have intent to kill, murder. If the facts say that I intended to cause serious bodily harm, we have the second leg, the second side of our murder square, which is our intent to inflict serious bodily harm, murder. Now, again, right, just to go back to something I said a couple minutes ago, if we were in the real world, said I wasn't going to talk about this anymore, so this, I promise, is the last time, I think. If we were in the real world, we might say, as the prosecutor in that scenario, well, there might be some other evidence that contradicts maybe me, the defendant's statement saying I didn't want to kill him, I only wanted to injure him. Maybe there's some other evidence out there, and so the prosecutor might charge and might want to try to prove that I am in fact guilty of intent to kill murder. Now I'm not saying that's what happens all the time or anything like that. What I'm saying is that there might be contradictory evidence. And so a situation like that where there are some facts saying, well, it looks like I had the intent to inflict bodily harm and not the intent to kill, there might be some other evidence that you as the prosecutor could say, well, hey, look at this. He does have the intent to kill. Not on MBE. On MBE, the only thing that we care about is what it says in the facts, and we take it. We take it absolutely as it is. That is gospel, as they say, right? That is absolutely true. We're not gonna question it. And so what we're going to do then in that case is we're just going to say, okay, if the facts tell me Bob intended to injure this person and I took whatever action, I hit him with the baseball bat, I ran him over with the car, and then they died, is Bob guilty of intent to kill murder? No. Is Bob guilty of intent to inflict serious bodily harm or murder on those facts? Yes. And so that is the distinction. And believe it or not, right, if you can get this point, that's a quarter of the murder questions on MBE is just that distinction. Because what the bar examiners will like to do is they'll get you arguing with yourself, especially if you've got not even just real world stuff, right? But like the way that we learn this in law school, because in law school we start talking about this whole malice of forethought thing and premeditation, and that we don't need to worry about that for MBE because that's not the way it's tested. And so what's cool about this is we just go by what the facts tell us. If the facts say I intended to kill this person, intent to kill murder. If the facts say I intended to injure this person, I intended to hurt this person, right? I intended to whatever, short of intending to kill them. In other words, I did not intend to kill them. I intended to whatever. It's not intent to kill murder, and that's really all we need to know. If there's another answer choice that gives us intent to inflict bodily harm murder, we have our answer, right? So that is the second side of our murder square. The third one I love talking about because it is tested. You're going to see it somewhere on the MBE. There's so many different ways. People get so confused with this idea of felony murder, but it's actually really simple, right? Because once we know what our enumerated felonies are, our inherently dangerous felonies, and then we have to be on the lookout for, sometimes they include another one. Once we know what those are, then all we have to do is say, okay, if a death occurs in the course of one of these felonies, it's felony murder. And if the death occurs in the course of a felony that's not one of these, it's not felony murder. And again, that's all we have to know. So let's talk about this. Let's kind of go basic, high-level definition. What is felony murder? A death occurs while in the course of the commission of a dangerous felony. An inherently dangerous felony is what they'll call it. And this you've seen, no doubt, you remember from first year law school, this is the BARC acronym, right? BARC, spelled like that. And it is burglary, arson, rape, robbery, and kidnapping. So if we have one of those crimes, right, those, remember, are inherently dangerous felonies. If we see on the fact pattern that our defendant is in the process of completing, and we'll talk about how far they have to get into it and all that stuff in a sec. But if we see our fact patterns have set up, and this will be clear, right? If the fact pattern's telling us that we have a burglary, an arson, a rape, a robbery, or a kidnapping, and we see that someone dies, right? So a death occurs in the course of the burglary, rape, robbery, arson, or kidnapping, right? To just keep it in order, the acronym, the burglary, arson, rape, robbery, kidnapping. If we see that the felony has occurred in one, or if we see that the death has occurred during the commission of one of those felonies, we have felony murder. Bob, what if the death occurred in a felony that's not one of those? What if the death occurred as a result of some other kind of felony? As someone smarter than me likes to say, it's not felony murder, and that's all you need to know for MBE. Right? We don't need to get into, well, what would it be? How would we handle the situation? No, no, no. If it's not burglary, arson, rape, robbery, kidnapping, if it's some other felony and the death occurs, it's not felony murder, and that's all you need to know. Now, I said sometimes there's an exception to that, and it's pretty simple. We're going to talk about, like I said, statutory stuff at the very end of this episode, but I'll throw in a little sprinkle of it here. Sometimes they will say, in this jurisdiction, such and such has been added to the list of inherently dangerous felonies. Or they will give you some other language that indicates they want you to treat this other felony that they're explicitly telling you what it is, because they have to, otherwise you wouldn't know. But if they tell you, we're going to treat larceny from a person as an inherently dangerous felony, right? Normally it would be robbery, and we don't need to worry about the specific distinction, but let's just say they tell you in the facts that they're going to treat larceny from a person as an inherently dangerous felony. And then they give you in the facts clearly that that's what I was doing, that's what and they could say it either directly to you that Bob's guilty of larceny from a person, or they'll lay out, these are the elements, and then they'll lay out in the facts, this is what the evidence will show, and it will show that I am guilty of each and every one of those elements. And then it's just going to ask you if can I be guilty of felony murder? Now, the way it'll ask you that is it'll say something like, what's the most serious crime that Bob can be convicted of? And answer choice A will say felony murder, and answer choice D will say larceny from a person. Well, if the facts told you that in this jurisdiction, and again, this is the exception, this is not the rule, don't go thinking you're going to see this, but I just want to be comprehensive. If the facts told you that in addition to burglary, arson, rape, robbery, and kidnapping, in addition to those crimes, I've added this other one that also meets the felony murder criteria, or in other words, we might say triggers the felony murder rule. Then if we have that crime being attempted or completed, right? If I intend that crime, if I intend the completion of that crime, and I'm committing that crime, and a death occurs, right? So a death occurs in the commission of this felony, that's going to be felony murder, and that's it, right? And again, if we're outside of typically burglary, arson, rape, robbery, kidnapping, or in those weird exception ones where they tell you, hey, test taker, in addition to the BARC felonies, pay attention to this other one. If we're in that scenario, okay, felony murder. Otherwise, if it's not burglary, arson, rape, robbery, kidnapping, am I guilty of felony murder? No. 0 out of 1,000 times. 0% of the time am I guilty of felony murder if it's not burglary, arson, rape, robbery, kidnapping, unless we have that crazy exception where they tell you. Okay. So those are our three kind of simplest, easiest sides of our murder square. Let's just kind of take a step back. Where are we at big picture? We're talking about homicide. And we said with homicide, there's essentially 6 crimes, but really we can break homicide into 4 murder crimes. That's our draw the square, make the square, our friends from England. That one. And then we also have the manslaughter piece, which we haven't gotten to yet. What is the difference, though, that I said between the murder crimes, the murder square, and the manslaughter piece? The element of intent, right? Because remember, when we get to the manslaughter piece, we're not going to talk about intent. What are we talking about here? What have we talked about so far? Well, we've talked about intent to kill murder, intent to inflict serious bodily harm murder, and felony murder. What is the common element of all 3 of those? The element of intent. Now, the intent's not the same. mind you. The intent is what is giving you the different answer, right? So what makes it one versus the other is going to be intent. But what is common in all of those, and what is ultimately going to be the dispositive element, is the idea that I, as the actor, have some bad intent, right? So what might those intents be? And this is what we talked about. I can intend to kill someone, in which case we have intent to kill murder, the first leg of our, or the first side of our square. I can not intend to kill them, and thus it's not intent to kill murder, while still intending to inflict serious bodily harm, right? I hit you with the baseball bat. In that case, we don't have intent to kill murder, but we do have intent to inflict serious bodily harm murder. And so that is going to be the second side of our square. The third piece was what we talked about with felony murder, right? And I gave you those bark crimes. Now, what is important with this, in addition to what I said so far, is that the actor, the defendant, what is their intent when that's happening? Well, their intent is the requisite intent for that crime. And we'll get into what each of those are in our next video, right, when we actually talk about these other crimes. But here's the point. They will tell you, okay, if I am intending, if it's a felony murder question, they will tell you that I am intending to rob this bank. And I'm in the process of robbing the bank, and that's when the shootout with the security guard happens, right? The town, I get the nun mask. I'm not doing that by accident, right? I'm intending to commit this inherently dangerous felony of robbery, and in doing that, the security guard gets killed, the shootout and all that, and the security guard dies. Well, there, it didn't say my intent was to kill the security guard. My intent was not to kill the security guard. I didn't intend for anybody to get hurt. I just wanted to get the money and get away. But there was a shootout, the security guard got killed, and now what is Bob guilty of? Guilty of felony murder. Why is it felony murder? Because my intent when the killing happened was, and this is where people get confused, right? Because they'll say, well, Bob, wait, what was your intent the instant, the millisecond when you pulled the trigger? No. What am I doing there? My intent was to rob the bank. I'm in the process of robbing the bank and the security guard dies. Is that intent to kill murder? No. But Bob, what if you pointed a gun right at him? If we're in the process of robbing the bank, it's felony murder. Doesn't matter if it was a lucky shot. Doesn't matter if I'm, the most elite marksman in history, right? If I'm robbing the bank, it's felony murder. If the facts tell you that I intend to kill this person, and we're not talking about an inherently dangerous felony, it's intent to kill murder. If the facts say that I want to hurt this person, but I don't want to kill him, it is intent to inflict serious bodily harm murder. So what's the big thing so far? If you've only gotten one thing out of what I've said so far, the biggest thing is that we need to read closely. Because where is all of this information contained? It's contained in the facts. What's the only thing that every test taker has equal access to when they're looking at this question? The facts, the fact pattern, right? What the bar examiners are giving you. They have to give you all of the information you need to know, okay, if it's a murder question and they're asking me to delineate between types of murder, and we know that the delineation between types of murder comes down to intent, they have to give you what the intent was. And then all you have to do as the bar taker is just trust. We have to divorce ourselves completely from our lawyer instinct, which is to question that evidence, right? And to look all, 360 degrees around it. Not on MBE. Not on MBE. On MBE, all we're doing, you tell me that's what the intent was. Okay, awesome. That's what the intent was. And that's it. All right, and then the final side of the murder square then is depraved heart murder. Now, depraved heart murder, I'm going to lay it out now. It will make more sense in about 20 minutes or so after I've had a chance to also go through the manslaughter stuff, because the way that this is tested, the way depraved heart murder is tested, unlike the three we've talked about so far, which are really tested based on your reading comprehension, your ability to trust, okay, this is what the intent was, as well as with felony murder, your ability to memorize, these are the felony murder triggers, right? The bark piece and everything else, that a death that happens not in one of those bark felonies, that's not felony murder. So that's how those first three sides are tested. This fourth side, though, depraved heart murder, what really they're going to get at is, okay, can you tell the difference between depraved heart murder and involuntary manslaughter? Again, we'll get there. So just big picture, what is depraved heart murder? This is a death that occurs as a result of my conduct, which this is the one kind of legalese piece. We'll get into it, but it's the type of conduct that evinces, right, that shows a reckless disregard. This is conduct that shows extreme indifference or a reckless disregard for human life. And essentially what we're talking about here is the conduct that, and what we're going to talk about here, the key thing, this is going to be reckless conduct causing a death as opposed to negligent conduct causing a death. Now, Bob, wait a minute. We said that there was intent touching all of the areas of the murder square here, right? Our 4 murder crimes. And while that is true, what we have to see here is that with depraved heart murder, we are not intending a death. So it would not be correct to simply say that in our murder square, our 4 types of murder, that intent to do something bad is necessarily required. However, what is the requisite intent that we're going to have for a depraved heart murder? What is the intent that has to be there? And in this case, again, it's not going to be an intent to kill. What this is going to be instead is this is going to be recklessness. The state of mind that is going to be required is the better way to think about this. What state of mind is going to be required? Or what is the requisite state of mind? This is recklessness. And similar to how we talk about the difference between recklessness and negligence in other areas, but we want to make sure here we understand the biggest distinction. This is going to be whether or not people are present. And so we're going to get into this when we see the manslaughter crimes in a second, how this is delineated. For now, just understand that this is going to be reckless conduct causing a death. When we're talking about recklessness versus negligence, what is the distinction? What's the difference? That the person knows or should know better, right? They know or should know there's a high likelihood that a death can occur as a result of whatever their conduct is. And so that's kind of the idea, right? Is the knowledge, the subjective knowledge of that actor. So we'll get into depraved heart murder, right? And kind of how that's different from the manslaughter cases. But so far, what do we have here? We have our 3 that we talked about where they're going to tell you, okay, this is what the intent was. And then this 4th one, depraved heart murder, what sort of mental state from our actor are we looking at? We want to see a person who's engaged in reckless conduct. Reckless as opposed to negligent. And what is the difference between recklessness and negligence? In the simplest terms for right now, it's going to be the knowledge of the risk, right? The actor's subjective knowledge of the risk. Do they know, or should they know, that the conduct they're engaging in has a high likelihood of resulting in death or serious injury, right? So that is depraved heart murder. Again, I know that that's probably not everything you want to know about depraved heart murder. Hang with me. Because next we should talk about manslaughter. And now there's two very different types of manslaughter. And we'll see that manslaughter can get confused, but it must never be confused with what we've talked about here so far, which is our 4 types of murder. And again, what is the big difference between manslaughter and murder? Manslaughter, we are never talking about intent. So we're going to talk about, there's 2 types. There's going to be involuntary manslaughter and voluntary manslaughter. So because I was just talking about depraved heart murder, I think it makes sense for me to start by talking about involuntary manslaughter. Then we'll circle back, we'll talk about the voluntary stuff. So involuntary manslaughter, this is going to be negligent conduct causing a death. And again, what is the difference, if we're talking just legally, the difference between recklessness and negligence? We're talking about the knowledge of the risk. Now we can talk about how it's going to be tested on MBE and this distinction that gets made. And I hinted at this earlier. Really what we want to look for when we're reading these fact patterns and we see, okay, there's this person, they were doing something that they shouldn't have been doing. You know, maybe they were really intoxicated. Maybe they were just doing something like really dumb or just really dangerous. They were doing something that they shouldn't have been doing. Now we look at the facts and we see, do the facts tell me that while I was doing this dangerous activity that I had the intent to kill someone? If no, then we don't have intent to kill murder. Let's just back up and let's say a death occurs at the end of this fact pattern. Okay, so what do we know? We know Bob was doing something really dangerous, really stupid. We know that a death occurred as a result of it. Okay, now let's read. The facts don't tell us that Bob had the intent to kill anyone. So we don't have intent to kill murder. The facts also don't say that I had the intent to injure anyone. They don't tell you Bob's intent was to injure this person who ultimately got killed. So we don't have intent to inflict serious bodily harm. Well, Bob, what if deep down in your heart you wanted... No. If the facts didn't say it, I didn't have that intent. Okay, felony murder. Well, let's see. Did the facts say that I was committing a burglary, an arson, a rape, robbery, or kidnapping? No, so it's not felony murder. Okay, so I'm doing something that's reckless or I'm doing something that's negligent. We know if the conduct is reckless, it's going to be depraved heart murder. We know if it's negligent, it's going to be involuntary manslaughter. But Bob, how do you really know the difference between recklessness and negligence? Isn't that an essay? Isn't that what lawyers get paid to argue? And of course it is. How do we handle this for MBE? We look and see if there are other people present in the fact pattern. Now, this is not 100% foolproof, but this is like 98% foolproof in terms of how to approach these questions. So we look at whatever conduct I'm engaged in, firing a gun. If I'm firing the gun out in the woods or into an abandoned building, somewhere where there's no people, there's no reason to suspect that there are people around, and God forbid someone is around and does get hit by the bullet and killed, well, then we're going to be talking about involuntary manslaughter. And why is it involuntary manslaughter? Because it's negligence, because I had no reason to know that there were other people around. I had no reason to know. So even if it's dangerous for me to be doing target practice in the woods, right? Even though that's dangerous because I'm firing a rifle or whatever. The idea is if I don't know that there should be people around, and it so happens that someone is, and the facts will tell you, Bob had no reason to know that anyone was around. Unbeknownst to Bob, there was a camper, da 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 da. And then the facts are going to say that the camper gets hit by this stray bullet. Is Bob guilty of depraved heart murder, or is Bob guilty of involuntary manslaughter? Well, on those facts, Bob is guilty of involuntary manslaughter. Why? Because the lack of the presence of people, right? Even though it turns out there was someone there, obviously, right? Otherwise, where would the dead body come from? Even though it turns out there was someone there, I didn't know anyone was there. I had no reason to know anyone was there. And so I'm engaged in this conduct. It's negligent, but it's not going to be murder. It's not going to be depraved heart murder. It's going to be involuntary manslaughter. And so that is that case. Now, same exact hypo, but let's say I know that there are people around, right? I'm in the woods, the woods, but it's the little, couple of feet wooded enclosure behind my house in the middle of a residential neighborhood. And I know that there's kids playing around and the mailman's walking through and there's a little path, people come with their dogs. The point is that I'm not out a million miles from everywhere. I'm in an area where, and the facts will tell you, this is a well-populated area. Everyone knows it's well-populated. Bob, when he's cleaning the rifle, sees 6 of his best friends all around, right? The idea is the presence of people. I, as the actor, am subjectively aware or should be aware. If the facts say that Bob, stopped at the 7-Eleven and, ripped a couple 12 packs on the way out to the hunting blind and then, whatever, I'm maybe not at that point subjectively aware of my surroundings, and we're going to talk about defenses, voluntary intoxication, all other stuff. But again, we keep this separate. We're not talking about defenses. We're not talking about voluntary intoxication. All we're saying is if the guy goes out, gets loaded, and then goes to the beach and he's polishing the rifle at the beach, bunch of people around, the spring break, right? And the guy's polishing the rifle and it goes off and it hits someone. Are we talking about negligent conduct? Is that involuntary manslaughter? Or is that depraved heart murder? Well, on those facts, that's going to be depraved heart murder. And why is that depraved heart murder as opposed to involuntary manslaughter? Because we were at a busy beach instead of in the middle of the woods, right? And so even if my guy who, was polishing the rifle is, just hammered, not aware of his surroundings at all, he thinks all the little people are, trees or like munchkins or something. I don't know. He thinks all the little people are not real people. Doesn't matter. That person knew or should know that there are people around. And so therefore, is it going to be involuntary manslaughter? No, because that conduct is not negligent anymore. Now that's reckless conduct. And again, what's the difference? The presence of people, the actor's subjective awareness of the risk. Okay, and so if that is our involuntary manslaughter, now we're going to talk about voluntary manslaughter. And here again, big distinction from how we talk about it in law school, how we learn it in law school, and how it looks in real life versus how we do it on MBE, right? Because in law school and in real life, we have this whole idea of mitigation, right? We can take something that is initially charged with murder and we mitigate it down to manslaughter. And that's absolutely, that's real life. We cannot do that on MBE. We don't mitigate on MBE. So in real life, you can take murder and you can mitigate to manslaughter, not on MBE. On MBE, there is no such thing. We are either talking about murder or manslaughter, and the two, for our purposes, are mutually exclusive. It is either murder or manslaughter. There's no mitigation. You're not going to see a situation, and that's really all we need to be clear about at this point with that. So forget that whole thing about taking a murder and mitigating it to manslaughter. Don't think about it like that. What we want to think about with voluntary manslaughter is this simple set of elements, right? So what do we have here? We have a killing, we have adequate provocation, and we have no cooling time, no time to cool off. Those elements are those elements are what make up voluntary manslaughter. If I don't have those elements, and particularly the dead body part, the killing is going to be easy to see, but particularly we're talking about adequate provocation and no time to cool off. If I don't have those elements, do I have voluntary manslaughter? No. If I have a killing on MBE and I have those elements and I have evidence of those elements, right? And we'll talk about what that is, of adequate provocation, no time to cool off. If I have those elements, is it murder? No. Is it voluntary manslaughter? Yes. Why? Because even though we had a killing, we had adequate provocation and no time to cool off. So you can see how, and again, this is why the whole idea of mitigation gets confusing for people, because you're saying, well, Bob, all this is stuff you could argue about, and it's true, but remember, MBE, we don't argue. So where do we go? Where do we go to get our information from? How we're going to handle this question? We go to the facts. Okay, and what do the facts tell us? Well, the classic voluntary manslaughter example, right? You come home, your spouse is in bed. There's serious examples of this, but old school, maybe a little funnier example, right? So what Luke Wilson comes home, okay, your spouse is in bed with another person. We don't have Vince Vaughn later to add a little levity to the situation. Let's say instead, God forbid, Luke Wilson picks up the lamp off the nightstand and kills somebody, right? If we have adequate provocation, your spouse is in bed with somebody, that's a classic law school example of adequate provocation. No time to cool off, so you're there in the moment, you're enraged, you pick up whatever you can find, you hit the person, and they die. At that point, because we have adequate provocation, and because we've had no cooling time, we are going to say it is voluntary manslaughter. But again, you say, Bob, isn't all of this stuff you could argue about, right? Whether or not the provocation was adequate, right? I mean, hey, Luke Wilson kind of laughs it off, and not really, but kind of being silly. But guys, come on, this is serious stuff we're talking about. How do we know if the person was placed in the heat of passion? They will tell you. They will say, Bob, upon seeing this, became enraged. Bob, upon seeing this, lost control. Bob, and they will give you something that says, I'm sweating, I'm nauseous, I'm in the heat of passion, right? I'm having some type of visceral physical reaction to whatever I'm seeing. How will you, as the test taker, know that the person is having that physical reaction where they're being placed in the heat of passion? They will tell you. And again, that's why we have to read closely. So that piece, again, though, why do I say it's easy to see? Because they have to tell you if I'm in the heat of passion or not. So that piece is pretty straightforward. Now, of course, it's not always going to be your spouse in bed with someone. I mean, that would be an easy one, but everybody knows that example. So what's a common way that I've seen this tested? A bar fight, right? People at the bar, and they're kind of getting into it, and somebody hits the other person or kicks the other person, slaps the other person, whatever. There's some type of physical, not to get technical, but there's some type of battery, right? Somebody hits the other person. Okay, then that's going to be adequate provocation for our purposes. Now, they may tell you that it's not adequate provocation. They might say, we're friends and Bob wasn't bothered by the slap. But then they'll tell you, they'll make it clear. Typically, if we're in the bar and somebody punches me, that's going to be adequate provocation for me to react, right? So now we have what might otherwise have been a murder. But we're not talking about murder anymore. And why are we not talking about murder? Because we have this element, we have this thing, this adequate provocation. So if we have provocation in our fact pattern, we're going to say, okay, they are testing me on the crime of voluntary manslaughter. Now, that's not enough to know whether or not we have voluntary manslaughter. That's not enough for me to know my answer. But if I'm reading the facts and I see what looks like and what reads clearly like, okay, they're talking about this person being provoked. Someone's going to die at the end of this fact pattern, and the person who, killed them, the person who initiates this, they had a reason to be angry. If we see that, okay, they're testing me on voluntary manslaughter. So can I pick an answer about murder? No. We'll talk about one kind of exception here, but no. No is the short answer. If we're talking about provocation, we're talking about voluntary manslaughter. Now, what is the other piece of this? The other piece of this is no time to cool off, right? The element of cooling time, cool reflection, the idea of we're contemplating the act, the act and the consequences, right, of killing this other person. Now, of course, an essay in your 1L crim class, the essay probably had something like there was a fight, and then, the guy got the gun and there's a scuffle, whatever. The one guy who ultimately does the killing ends up on top of the other person, and then they point the gun at him and they pause for, a second or 6 seconds or whatever, and then they shoot them. Or they shoot them once and then they pause for 3 seconds and then they shoot them again. And the idea with the essay being, of course, they want you to argue, okay, where does the cool reflection actually occur? And in that split second, because we know from the case law, there's that split second where the person can form the don't do that. Don't do that on MBE. Here is what's going to be the case. They're going to make it very obvious. Either you hit me in the bar and I pull out the gun immediately and shoot you, right? In which case we're going to have voluntary manslaughter. Why is it voluntary manslaughter? Adequate provocation, and the killing happened immediately. There's no time to cool off. How do you know there was no time to cool off? The killing happened immediately. They said in the facts, immediately after. They will 7.5 times out of 10 use the word immediately, right? So the idea is they will tell you if there's no time to cool off. Or they will say that we got in the fight at the bar and then I was angry and I left and I went home and I thought, wow, I really want to kill that guy. And then I went and I got the gun and then I drove back to the bar and I sought the person out and then I killed him. So in that case, right, if it's not immediate, if they tell you that this other stuff happened in between, are we still talking about voluntary manslaughter anymore? No. And so this was my one hesitation when I said, okay, if we have adequate provocation in the facts, that we're not talking about murder. Because this, what I've said here now, this would and could be murder, right? And not voluntary manslaughter. So sometimes they will say, what is the most serious form of homicide that Bob can be convicted of? And let's go through these facts really quickly. So we're in the bar, you punch me, I get mad, I go home, I think, wow, it would be great to kill this guy. Then I grab the gun, I go back to the bar, find you, and shoot you. On those facts, answer choice A says voluntary manslaughter, and answer choice D says intent to kill, murder. Well, there was adequate provocation in those facts, but I left. There was time to cool off. So are all of our elements for voluntary manslaughter met? No. And so this is why I want you to think about it this way. If we see adequate provocation in the fact pattern, okay, I know that the thrust of this question, even if the correct answer ends up being murder, like in this example that we're talking about, the thrust of this question is testing me on the elements of voluntary manslaughter. And do I understand that one of the essential, required elements of voluntary manslaughter is the idea of no time to cool off, no cooling time? That is an essential element. And so, okay, I recognize there's adequate provocation in these facts. Adequate provocation happens. Now, what do I need to look for first? Then I'm put in the heat of passion. So if the facts say that we're buddies and I didn't get mad and I'm, whatever, I didn't get mad, I was not placed in the heat of passion. If the facts tell you that, do we have adequate provocation? No. If the facts say that Bob's enraged, Bob's angry, Bob's nauseous and starts sweating, whatever, if they say that I am placed in the heat of passion, okay, we're still on track for a voluntary manslaughter answer. We're still thinking, yep, okay, they've given us the elements. But now we come to this other element. We come to this no time to cool off, right? The presence or lack of presence of cooling time. And remember, what do we say with cooling time? That is the careful, deliberate reflection, right? We're deliberately thinking about whether or not we're going to kill this person. Did the action, whatever I did that caused the death, did it happen immediately after the adequate provocation while I'm still enraged? If so, our elements are met and we have voluntary manslaughter. If no, if I went home, if I did something else in between, and then as I'm doing that, as I'm going to get the gun, I'm thinking about this, right? Even if I'm still angry, even if I'm still in the heat of passion, right? If we don't have that lack of cooling time, in other words, if it's not instantaneous, it's not going to be voluntary manslaughter. Voluntary manslaughter is not going to be the correct answer to that question. And so once we know that, okay, we know they're testing me on voluntary manslaughter, but I know they've removed one of the elements that would make it voluntary manslaughter. In other words, they've taken away that lack of cooling time, or to avoid using a double negative, they've given us cooling time where we know the absence of that cooling time is the required element. But if we see that cooling time, okay, I know it's not voluntary manslaughter. And so either if they give it to me in the facts, they give me the other stuff that we talked about that makes it fit into the murder box, i.e. my intent was to kill the guy, then we know we're talking about murder. But if murder is not one of the answer choices, if the answer choices are voluntary manslaughter, involuntary manslaughter, larceny, and no crime, what's the correct answer there? So I killed the guy, but there was cooling time. And we know involuntary manslaughter is that whole thing with negligence and no people present, right? And so we know it's not going to be that answer. And, well, it can't be larceny because I didn't even tell you that I took anything. So the answer there is going to be no crime. And that's an example of where people get hung up on the conclusion. And they say, well, wait a minute, you just murdered this guy. He just absolutely came back in cold blood, killed this guy. And you're telling me, bar examiners, the correct answer is no crime? Yes. Because it wasn't a question about whether or not, it wasn't a question about, from a public policy standpoint, whether or not we should let this guy go free. It's a question about whether you, the bar taker, recognize that before you can pick an answer talking about voluntary manslaughter, that all of the elements of voluntary manslaughter better be met. And what element of voluntary manslaughter was missing from the facts they gave you? The element of lack of cooling time, the absence of cooling time. So the answer, stupid as it is going to be no crime. And guys, if you can get that, beautiful. Oh gosh, that's huge. That's huge. So, okay, those are our homicide crimes kind of overview. Let's just kind of really quick back through what do we have. We have our make the square our murder square, right? And in there we have intent to kill murder, intent to inflict serious bodily harm murder, and felony murder, right? Then the fourth part of that square, where there's a little bit where it can get a little tricky, right? This is depraved heart murder. What is depraved heart murder? What's my mental state? What do I got to be doing? I got to be acting recklessly, right? Reckless indifference, extreme disregard for human life. I'm doing something that's not just negligent. I'm doing something that's reckless, doing something where there's people around, right? Those are our murder crimes, finishing out with depraved heart murder there. Then we go outside of that square and we have this idea of involuntary manslaughter. Involuntary manslaughter, remember, that's the one they're going to test in connection with depraved heart murder. And what's going to be the difference there? What's that going to turn on? The presence of people. Am I doing the stupid thing in the middle of the woods where no one's around and it just so happens that someone gets killed? Involuntary manslaughter. Am I doing the thing where everybody's around and the death happens? Depraved heart murder. What's the difference? My subjective knowledge of the risk, right? I knew or should know that a death was likely to occur from whatever I was doing. And then finally, for homicide, we have this idea of voluntary manslaughter. Voluntary manslaughter, we either have all the elements met and we have voluntary manslaughter, or we don't and we don't have voluntary manslaughter. And it is just that simple. So how do we know we're talking about voluntary manslaughter? We have a fact pattern where the guy who does the killing has a reason to be pissed off, right? The guy or girl, right? It doesn't have to be a guy, right? But the person who does the killing had adequate provocation, right? They were provoked. They found their spouse in bed with someone else. They got into a fight at the bar. Somebody, whatever. The idea is they've told you there's adequate provocation. Now, again, how do you know that whatever the provocation they're talking about was adequate so as to satisfy that first element? Because they're going to tell you the person, the farmer, whatever, was enraged. They were overcome with anger. They're going to give you something that says this person is in the heat of passion. And then to determine whether or not we have voluntary manslaughter or not voluntary manslaughter, right, or something else, the idea is whether or not the person had time to cool off. And if it is instantaneous, there's no cooling time. And so we're going to say that it is voluntary manslaughter, right? Because the no cooling time element is met. If the person went home, went around the block, got a sandwich, whatever, if there's obviously cooling time, it's not voluntary manslaughter. So in other words, yeah, the facts have set it up that it's somewhat ambiguous, but then they've told you, yeah, okay, this is what we're testing you on. It's this element. Then all we have to do is just follow through and pick the answer choice that connects this element to what the facts are talking about. That last piece will make more sense once you've seen a few examples of this. But as always, big picture, guys, what are we really talking about? Talking about reading comprehension, right? Slow is smooth, smooth is fast. And the confidence, okay, they are asking me about one of these death crimes. We have a dead body. And all I have to do, I draw my little square and I say, okay, well, now let's kind of plot this out. What is the intent of the person? Did they tell me anything about intent? If there's nothing about intent, okay, well, are we talking about negligent conduct or are we talking about reckless conduct? If it's reckless conduct, well, we're back up in that murder box there. If it's negligent conduct, because no one was around, I had no reason to know anything bad was going to happen, then we're talking about involuntary manslaughter. If they are giving me facts that talk about provocation, I go through, I see if my voluntary manslaughter elements are met. If they are, great, voluntary manslaughter is my answer. If they're not, then I'm going to pick whichever answer makes sense based on the remainder of the fact pattern. And that's it, guys. That's what we have to know for homicide. In the next episode, we're going to get into the other crimes, just kind of keep rolling through this. But until then, I love each and every one of you. Look forward to getting into this a little bit deeper. As always, get at me with any questions that you have. We're going to get through this together. I believe in you. Like I said, I love you. See you next time.